Welcome to the first of what will be a series of webinars on various topics of importance to the Policy and Taxation Group supporters and FEUSA members. Today, we will hear from Brandon Ramon, Senior Associate at Squire Patton Boggs, about a legislative proposal, the Corporate Transparency Act, that if enacted, would require businesses to file even more paperwork with the federal government and create significant privacy concerns. To kick things off, Brandon, could you please provide us with some additional background on the proposal?
Thanks, Pat, and hello, everyone. It's good to be with you. I appreciate the opportunity to talk to you about this important piece of legislation. So to kick off, as you asked, Pat, I think that it will be helpful to give some context to what the Corporate Transparency Act is by understanding what it would change under current federal law. So until the Financial Crimes Enforcement Network implemented a final customer due diligence rule under the Obama administration in 2017, so-called covered financial institutions were not required to know the identity of those individuals who controlled or owned the legal entity of their customers. And so those people are known as the beneficial owners. Under the beneficial ownership rule, which was part of the customer due diligence requirement to implement the bank secrecy and anti-money laundering regime here in the United States, a bank was required to establish and maintain a written procedure that would reasonably be designed to help identify and verify who the actual beneficial owners of a customer was, and then also to include procedures in that so that it's part of its anti-money laundering program and meets the requirements under federal laws and regulations. But over the last several Congresses, given the increased concern about terrorist financing and other illicit activities, there's been an effort in Congress to look at ways to analyze the current regime and improve and strengthen it to help tamper down on the activities that are being undertaken by some illicit actors. So one example, which I'll talk about a little bit more today, is the Corporate Transparency Act, which, as you mentioned earlier, would require FinCEN to amend its regulations and then require certain corporations and LLCs to provide identifying information to them about the beneficial owners of certain corporate entities.
So, Brandon, it sounds to me as if the enactment of the Corporate Transparency Act would increase the significant regulatory burden already placed on family businesses. So I think it would be helpful if you could provide an update as to where things currently stand with regard to the Corporate Transparency Act, along with an overview of what the proposal would actually mean for our supporters and our members.
It's a great question, Pat, and I'm happy to do it. So as to the current status, there were two competing versions of the Corporate Transparency Act. In the House, it was sponsored by Congresswoman Carolyn Maloney from New York, who's a Democrat, serves on the Financial Services Committee and also chairs now the Oversight Committee. Her legislation was actually submitted as an amendment to what's called the National Defense Authorization Act, which is legislation that's enacted every year by Congress to set the Pentagon's priorities for the next fiscal year. As I mentioned, she offered it as an amendment. It was accepted and incorporated into the House-passed NDAA, which the House passed in June of this year. On the Senate side, their version of the NDAA is called the Illicit Cash Act. It was something that's led by the chairman and ranking member of the Senate Banking Committee, which has direct jurisdiction over these financial services and banking issues, and also supported by a number of other committee members. However, given the lack of nexus to the NDAA, there was concern about including it as an amendment, so the amendment, Illicit Cash Act, was never adopted, and the Senate passed its bill without including the parent or the co-part to the Corporate Transparency Act on the House side. And I will note, and I think it's important to say that thanks to your leadership, Pat, and others in the organization, we joined with the NFIB and about 70 or so other organizations to sign a letter on behalf of these business groups and other interested parties to oppose the inclusion. And this was one of the key reasons that the Senate ultimately did not include the Corporate Transparency Act in its NDAA. So in terms of now that we have the kind of context and the background of the legislation, what does it actually do? So it will require, as I mentioned earlier, companies to disclose information about the beneficial owners when they are formed. And then as Representative Maloney said, who, as I mentioned, is the lead sponsor, it's intended to prevent bad actors from using anonymous shell companies to thwart law enforcement and hide their illicit activities. So let me go through a couple specifics. First, this will require corporations and LLCs to disclose their true beneficial owners to FinCEN when the company is formed. It also does have certain exemptions for trusts and other types of formed entities that are not traditional corporate entities like a corporation or an LLC. It would establish, and also let me just point out, this is important, that it's really focused on small business. So those with 20 or fewer employees would have to submit this on an annual basis. It establishes the minimum beneficial ownership disclosure requirements, and as you can see here, the companies are required to provide the owner's name, the owner's date of birth, their current address, and then a driver's license number or non-expired passport number. And again, these are required for anyone with a 25% ownership stake in the business or anyone who receives economic assistance from the business. And it would need to be submitted on an annual basis. So the amendment, this is important also to note, so on a beginning effective immediately if this is enacted, companies will be required as they are formed to submit the information directly to FinCEN, and then existing entities would have to begin doing so within 2 years. It's also important to note that if you do not do this, you could potentially face both civil and criminal penalties, so fines of up to $10,000 and then criminal penalties of up to 3 years in prison. So there's really significant risk factors for those who do not comply. I'll also make note that currently, as I mentioned earlier with regard to the customer due diligence rule, banks are those who actually are required to possess this information, and so it's not surprising that it's largely banks and other financial institutions that are those that are pushing this change, because it will sort of remove some of their responsibilities and put the burden more onto the business owners. Right now, in addition to the regulatory burden, because this again is estimated to cost about $5.7 billion in regulatory costs and about 131.7 million hours of paperwork over the next 10 years. Because of that, there's concerns, but beyond that, there's also concerns about privacy and the potential leak of information. So as I mentioned earlier, banks are those who currently possess this information for their business clients, and it's only accessible via a warrant. And then, unfortunately, the way that this legislation is drafted, there would be a database that would include information of about 25 to 30 million business owners. It would be searchable by local, state, and federal law enforcement officers with no subpoena. And the concern, I think, largely is that this, because it's accessible by such a large number of people with no real requirement to show cause, that there could potentially be misuse of this customer information that could be made public and have negative implications, and pose potentially burdens on business owners. So there's lots of concerns out there about the legislation, and that's kind of in a summation of what it would do.
So Brandon, you're absolutely right. This is grave concern to families, family businesses, and family offices, not just because of the regulatory burden, but also the privacy concerns as you've raised. So for purposes of our supporters and our members' strategic planning, could you please give us your assessment of the potential next steps, which should include the timing and the ultimate chances of success of enactment of this bill?
I'm happy to, and that's a great question. As we do on the policy and taxation side on the Hill, it's important to be engaged and make your voices heard. So let me give you the current status. As I mentioned earlier, we talked about both the House and Senate have passed their legislation. So for those not familiar with the legislative process, the next step in that, because the legislation passed by the House and Senate must be the same, and the two bills that were passed on the NDAA front are both different, they need to go through what's called a conference, where there's a reconciliation of the differences, different provisions, so they come to an agreement on one similar, same bill that both the House and Senate will pass. Typically, the NDAA runs through the fiscal year, so one fiscal year, October 1, to the end of that fiscal year, September 30th. On a traditional basis, there has been an effort to pass the NDAA by September 30th to, along with all the other appropriations bills, make sure that the government is up, running, and funded at the beginning of the next fiscal year for the duration. As you all no doubt know, over the last several years, doing that has been a challenge, and this year poses no difference for purposes of passing a appropriations bill, including the NDAA. So current expectations are, because conferees have yet to be named, that the lawmakers will pass what's called a continuing resolution, which just means it's also called a CR, but that basically is a short period of time where there's very few policy changes and then just a specific window of extended funding from the old fiscal year to the next to allow lawmakers an opportunity to reach agreement on a longer-term spending bill. We expect that will be the case this year, so the Corporate Transparency Act provision, if it's resolved as part of the NDAA, which right now seems fairly likely to be, it would be something that will happen likely in the lame duck session, so after the election in November. Again, there's lots of moving pieces, and that we can never really fully predict anything here in Washington, but I will just say again, there is an effort to include it, and there's a lot of push from financial institutions and the banking community to try to shift some of the burden from the banks to the individual businesses themselves. So there will be a push there. But as I referenced earlier, the NFIB, the National Federation of Independent Business, along with other supporters like the Policy and Taxation Group, have been also pushing back in favor of not moving forward with this proposal to help support small businesses at a time when they're already struggling. So we will have to see. It's hard to give a full prognosis right now, but there will be a battle through at least November, most likely, on this legislation. The last thing I'll mention in terms of the kind of prognosis and another data point to take into account is the fact that Secretary of the Treasury, Steven Mnuchin, is a big fan and supports the Corporate Transparency Act, having come from the financial world himself. So if it does not get adopted as part of the NDAA, we do expect that he may try to push this as part of another COVID-19 economic relief package. So we've been calling it a whack-a-mole effort that will be requiring close monitoring and diligence throughout the remainder of the year, but we are here standing by and ready to do so, and we'll certainly keep everybody apprised as things continue to develop.
So Brandon, that is very helpful, and as you just said, families have to pay attention to this, because if it doesn't happen through this bill, it may happen through an alternative method or legislation. So I want to really thank you today for leading this very helpful discussion. I want to thank all of our supporters and ask them to please be advised that we are closely coordinating this effort. We are working with the National Federation of Independent Businesses, as Brandon already mentioned, and have expressed our strong opposition to the corporate transparency bill to policymakers. We've signed many letters, both FEUSA as well as Policy and Taxation Group. If you have any follow-up questions regarding this legislation, please feel free to reach out directly to Brandon, and you'll see on the next slide his contact information. He can be reached at brandon.ramon@squirepb.com. I want to thank all of our Policy and Taxation Group supporters and our Family Enterprise USA members who are participating in this webinar, and I want to thank you all once again for your continued support of our missions. This is a very important mission for both organizations, and we cannot do it without you. Thank you again.